The defense attorney, who I had a good working relationship with, calls me up. He's furious. He says, "Gerry, I just got this lawsuit. I just spoke to my client. What are you doing suing Dr. Jones?" And I say, "Let me tell you why Dr. Jones is in this case. You want to know what this is about? Come join me in this walk as I share with you some beautiful information about why Dr. Jones is in this case." Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, I'm glad you're joining me on this beautiful walk. I'm here in St. Martin on a deserted island, literally. And now, if you look behind me, there's a deserted island, which is really nothing more than shells and rocks. My wife, by the way, loves to pick seashells. In the background, all the way in the back, is where we originally walked from, my wife and I walked from, and that's known as Coralita Beach. It's on the French side of St. Martin. So since my wife loves to pick shells, she dragged me along here to go pick some seashells on this deserted island here that she calls Shell Island. And now, if that's not enough, she's asked me to come join her on this other rock outcropping, which is also a deserted island, but beautiful. Thankfully, it's as if the Red Seas have been parted, and now we're able to walk straight up without having to wade through some high-level water. Now, I get a call from the defense attorney who I know for a long time. We've worked together on other cases. I respect him, he respects me, and now he says to me, "I don't understand. I just got a call from my client who tells me he just got sued. He just got served papers by your law firm, by you." It's like, why did you sue him? I spoke to my client. He claims he did absolutely nothing wrong. He claims that if there is someone who did something wrong, it wasn't him, it was these other doctors who were involved. And now I begin to have a conversation with the defense attorney. And I begin to calmly explain to him exactly why we believe this doctor is liable, why we believe that this doctor violated the basic standards of medical care. Now, one of two things will happen during the course of this conversation. Either we will reach an impasse where we believe our set of facts are true, and the defense attorney will believe that his set of facts are true, and they are completely incongruent. They're totally opposite. In that instance, we can't get past this impasse, at least not in this telephone conversation. So what happens in that instance? In that instance, I have to say, "Listen, I'm sorry, but my expert confirms that we do have a case. That's why we brought this lawsuit." You know, if facts turn out to be different later on during the course of the litigation, I'll be happy to reevaluate and reassess it. And if it is appropriate, then yes, I'll let your client out of the case at the right time. But now is not the right time. On the other hand, the doctor's attorney, the defense attorney, may turn around and provide insight or information to me that we didn't know about. You see, when we review these medical records to determine whether or not you have a valid basis for a case, we are often limited by our client, the injured patient's version of the events and what they remember, together with what's contained in the medical records. So you may not know this, but we actually use the doctor's own records to determine whether or not he violated the basic standards of medical care. The inherent problem with doing it, with using the doctor's or the hospital's own records to identify whether or not something was done wrong, is that there may be missing information. There may be information that happened that was never recorded. In that instance, now I'm relying on the doctor's attorney to have a conversation with his client to learn to get more information about stuff that none of us who are now involved in the litigation knew about. But the people who were involved in the day-to-day care might have that information. So once that information comes to light, if it's favorable to the doctor, now it puts his request in a different light. It may be a very good reason why our expert determined initially, based on the medical records, that this doctor belonged in the case. If it turns out that we were wrong and did not have all the facts necessary to make a proper evaluation, then yes, by all means, this doctor should not be in this case. But until we have confirmation, until we have proof that what this attorney is saying is correct, I can't let the doctor out of the case at this point. I need confirmation, I need proof from other sources that what he's saying is correct and true. If it turns out that he is correct and true, then guess what? Then I don't want him in this case. I don't want him muddying the water and pointing fingers at my client or pointing fingers at other people. Why? Because now things will get confusing. If the doctor and his attorney can confirm for me that this doctor does not belong in this case and did not violate the basic standards of medical care, then by all means I will let them out, because there's no valid basis, no valid explanation for keeping them in the case. So why do I share this quick information with you? I share it with you because I wanted you to see this beautiful scenery. No, I wanted to share it with you to explain to you what does happen from time to time in these medical malpractice cases in New York. You know, I recognize that you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.